Good morning, Mr. Costello.
Good morning, Your Honors. Good morning, members of the Court. My name is Patrick Costello, Town Council for the Town of Billerica. I'm here on this matter representing the Zoning Board of Appeals.
Mr. Costello, it's obvious that there was the decision of Judge McAvoy that's at issue here was issued in September of '03. It is now April of '09.
Correct.
And I understand the transcript was lost, but it took 6 years or 5 years to that seems a mighty long time.
It is an awful long time, Your Honor. I unfortunately was not trial counsel in this case for the town. I just recently was assigned this case as town counsel. I do understand that the recordings of the trial proceedings were in fact lost, and the case did follow the due course of appeal from that point in time through the courts, and this is the first assignment we've had for this court. As you know, this court removed the matter from the appeals court.
Right. No, it seems like a so my connected question to that is between 97 was when this effort to get a modification occurred, so that's 12 years ago. What's happening now?
The Wendy's is continuing to operate as it always has, Your Honor, as was approved by the 1992 special permit and variances.
With one entrance egress.
That's correct, Your Honor.
Okay.
I have a question, it's just a general question. Are there different standards of review for a variance and for a special permit?
There are different statutory provisions, Your Honor, that govern them. Chapter 48, Section 9 addresses special permits. Section 10 addresses variances. But the standard of review at the appellate level or in the court level is, in fact, the same, Your Honor. I would suggest that that level of review is that a special permit or variance as zoning relief must be determined by the court to be based on a legally tenable basis, and it cannot be arbitrary, capricious, whimsical, or unreasonable. Boards, permit-granting authorities do technically have more authority or more discretion or leeway with regard to special permits than they do to variances. The statute does establish 3 strict criteria for the granting of variances, whereby special permits, which are permits which allow otherwise prohibited uses within the town, are given more leeway to impose conditions and safeguards.
Mr. Costello, is the board saying that Wendy should have known back in 1992 that there was going to be the construction that was coming in the future and that they should have appealed then?
I think there was an inference that that is the case, Your Honor, but that is not the crux of our argument. Our argument is that in 1992, at the time the original special permits and variants were granted, the issue relative to access onto Pollard Street was specifically addressed by the board. It was made known at that point in time that there were concerns relative to traffic impacts that this proposed project could have on the residential neighborhood, which directly abutted Route 3A, Boston Street, where the Wendy's is located. At that point in time, the initial plan proposed by the applicant, Wendy's, did show the dual access and egress points, one on Route 3, one on Pollard Ave. The board specifically addressed that by imposing a condition prohibiting access onto Pollard Ave and requiring that the green strip be extended where the proposed access on Pollard Ave was initially shown.
Right. Is the jurisprudence under Section 17 of Chapter 48 the same as it was under the former Section 21, which, as I understand it, is that although a superior court reviews these matters de novo, the superior court does not have the authority to order a grant of the variance or the special permit?
That has been the jurisprudence that has been evolved, Your Honor, through this case. I do believe that this court, the trial court, the superior court in this case, clearly has de novo proceedings. And I believe the fact-finding aspects of that de novo proceeding are different than the standard of imposing the court's judgment or discretion in lieu of that the board exercises.
You say in your brief along the same lines, of note is the trial court's failure to find that the board's decision was legally untenable or the result of arbitrary, capricious, whimsical, or unreasonable behavior. But isn't that exactly what she did? She said that there was no explanation or evidence or inference of what detriment to the public good there might be, and she said even giving deference to the board, nothing in the record supports its conclusion. So she did exactly what you're criticizing her for not doing, it seems to me.
Well, that's the second point of our argument, Your Honor, the lack of completeness in the trial court's decision. We allege in the first instance that there was no jurisdiction in the court based upon the failure to comply with the 4817
say that the
timeline.
plaintiff, how was the plaintiff agreed back when the first permit was granted? They got what they wanted. They weren't aggrieved.
To address your initial point, Your Honor, I believe that this court and the appeals court in the Commonwealth has established through numerous cases that the role of a trial court in these appeals is somewhat limited or constricted. The trial court cannot substitute itself for the local board with respect to the level of discretion and judgment that may be exercised.
Mr. Costello, in this case, as I understand this record, and I haven't read it, but the evidence presented before Judge McAvoy included a number of town officials saying this is okay, somebody from the state highway, Mass Highway Department saying this is just fine, no traffic problem. So all the evidence before her is that there isn't a traffic problem because you didn't call any witnesses or put in any evidence. That's her evidence, and there's also evidence that in fact, I think some of those witnesses are saying that it's actually safer to have an exit on Pollard Ave because now that you can't turn left onto Route 3, it's a problem to have to go around. So all this evidence 6 years later is that there's no evidence saying it's not workable. There's no evidence saying it presents a traffic problem, and there is evidence that it's safer. What is she supposed to do? Give it back to you again? I mean, it just seems to me you could keep going on this forever.
Your Honor, I believe that at the hearing in 1992, when these issues were first addressed, the board specifically considered those issues, rendered a decision. I think the premise has to be recognized that a special permit or a variance is a privilege. It is not an entitlement. It is up to the local permit granting authority in the first instance to make a determination whether or not the neighborhood interests or concerns, which are specifically addressed in the Billerica bylaw, are being adequately preserved and safeguarded by the application.
But did the Zoning Board of Appeals call any of these? I think the record shows that there were 2 people that lived on Pollard Street that testified before the board. Were those 2 people or any other people from Pollard Avenue called to testify at the hearing before the Superior Court judge?
No, they weren't, Your Honor. The town introduced no witness testimony at the trial.
But you did introduce some evidence.
The record of the proceedings below were introduced as evidence at the trial, yes, Your
And
Honor.
that would that include some reference to the testimony of these
Yes, it
residents?
did. The
What
minutes
were
to the
the-
meeting would have
What
included.
were the board's findings?
The board concluded that the...
No, not its conclusions. What were its findings?
The findings. The findings are specifically set forth in the brief, Your Honor, that the...
But there were no factual findings.
There were findings that there would be a negative impact on the neighborhood due to the increase in
That is
traffic.
the conclusion. I'm asking you, what were the board's findings?
The board did not make specific factual
Okay,
findings. Your
so
Honor.
how
Okay.
can the judge err? I mean, there were no findings. How was the judge wrong in saying there were no findings to support the conclusion?
I would note, Your Honor, the well-established principle that when a local permit granting authority denies zoning relief, the standard or quantum of findings that are mandated is much lesser than...
Okay, but there were no findings. I agree with you that your statement is correct, but there were no findings.
The board did make a finding, Your Honor, that the proposed traffic or the access from Wendy's onto Pollard Street would be detrimental to the neighborhood.
Now, there were 2 hearings before the Superior Court, one after a 4-to-1 vote, one after a 3-to-2 vote, right? And
Yes,
the
Your
court
Honor. remanded
the matter as a result of a joint motion after the 4-to-1 vote.
Yes, Your Honor.
Now, when it, what was, I saw something in the record that, or in the brief that suggested that one of the reasons that may have been, there may have been a joint request to remand was that there was going to be a relocation of the proposed curb cuts on Pollard Street.
Okay.
So did the plans change after the first vote and the second vote?
I can address that very succinctly, Your Honor. The reason there was the remand was at the same time that this case, the first appeal was pending in the Superior Court, there was a second action filed by the plaintiff for an assessment of damages under Chapter 79 as a result of the eminent domain taking. My understanding of the record is that at the time this matter was remanded to the Superior Court, there had been settlement discussions underway between the parties to find a resolution to the Chapter 79 assessment of damages case. So the matter was remanded to the Superior Court for further deliberations before the Zoning Board of Appeals in an effort or a hope by the parties that the Zoning Board of Appeals would in fact approve the modification, allow the secondary access that would have had a direct impact upon the pending Chapter 79 litigation.
Did the location of the access onto Pollard Avenue change after the 4-1 vote and before the ZBA took the 3-2 vote?
No, I believe it was always proposed at
In
the
the same
same
place.
location.
Does the record indicate whether or not the takings case, the damages case, took into consideration the loss of business to Wendy's as a result of the change in traffic?
The record doesn't, Your Honor. All the record has...
It does or it does not?
It does not. It just has the complaint filed in the eminent domain case plus the judgment and an execution. I would suggest, Your Honor, that on that point, however, the fact that the Chapter 79 assessment of damages claim was filed with the Superior Court further supports the town's position that this would be a second bite of the apple, if you will. As the Court knows, in an assessment of damages case, a property owner is compensated not only for the loss of property that is taken by eminent domain, but for the diminution in value of the remainder of his property. That would include factors such as decrease in value of the property as a result of restriction on business activities or permitted uses. I note in this particular case that there was, in fact, no diminution in the value of the property in terms of restricted access to the property. The property still did have legal access. The business operations, as approved in 1992 and as constructed and conducted since that point in time, were fully capable of proceeding in that regard. I would suggest to the Court that the only thing that changed as a result of the eminent domain taking would be the convenience, if you will, of the patrons and operators of the Wendy's location. That is not a factor that the Zoning Board of Appeals was bound to abide by or to issue a...
Well, convenience or safety.
Correct.
I mean, now you've got to cut across 2 lanes of traffic to get into the driveway as opposed to 1.
3.
That's a big
Correct.
difference. Trust me, I live on such a street. I know exactly the difference between it.
But the Board, by its very bylaw, had a right to consider negative impacts from increased traffic into the neighborhood. The mere fact that a curb cut would have been allowed on Pollard Street or could have been allowed on Pollard Street would de facto have resulted in more traffic on that street than it existed prior to the existence of the curb
Wasn't
cut.
the evidence, though, Mr. Costello, the actual evidence that it would have had negligible impact?
I believe it was minimal impact, is what the plaintiff's expert testified at trial, Your Honor. But the mere fact that there was minimal impact established at trial, I would suggest, goes back to the deference and judgment that is within the prerogative of the Zoning Board of Appeals to exercise, not the Court.
If you're right about that, a Superior Court judge could never overrule a zoning board with respect to it, because there's always going to be some increase in traffic in such a circumstance. So by your standard, the Superior Court hearing would be a formality, wouldn't it?
Not really, Your Honor. I think what we're dealing with here in this particular case is a motion to modify a special permit by removing conditions that were imposed at the outset. I think it's a collateral attack on the initial imposition.
But the circumstances have changed.
The circumstances have changed as a result of an eminent domain taking, for which there is a specific and exclusive statutory remedy, the assessment of damages.
But are you saying that if a judge finds that there is any increase in traffic, that is sufficient to support the finding of the board, even if that additional increase in traffic is inconsequential?
I believe that under the well-established case law decided by this Court and the Appeals Court, it is the prerogative of the Zoning Board of Appeals to make that call, and that courts should not overturn or usurp that authority so long as there is a basis by which a rational permit-granting authority could have concluded that there is a negative impact. And I suggest that that was established here.
Thank you, Mr. Costello.
Thank you, Your Honors.
Good morning, James Dangor Jr. for Wendy's Old Fashioned Hamburgers.
Good morning, Mr. Dangor.
Very quickly on this, the Section 17 issue and whether or not this court has jurisdiction to hear this, I suggest what's before this court is an analysis under Section 16 of 40A, the Zoning Act, as opposed to 40A-17, which calls for that 20-day appeal period.
Going back to that, it's my understanding that the challenge before the judge was not of the 92 finding, but of the 97 finding. Is that correct?
That is correct, and that was the denial of the modification. That's correct. There were under the Section 16 analysis involves a change in circumstance, as Justice Bosbet had indicated. In this case, after the design was completed, after the taking was completed, we went back and sought to remove that.
But why is a change in circumstance relevant? Because Section 16 permits you without a change in circumstance after 2 years have passed.
That's one of the points that I was going to get to later. If you do it within the first 2 years, you need planning board approval. Okay.
Right, but
if you do it beyond that, all you need to do is satisfy the public notice requirement. Now, what counsel, I believe, is alluding to is there's a distinction between a late filed, delinquently filed challenge of the validity of a zoning bylaw versus a change in circumstance. And counsel in the town cite Klein and they cite Iodice. And in both those cases, there were challenges, although well beyond the 20-day period, of whether or not certain zoning bylaws were valid or not as applied to a particular project. So in that case, I think both courts recognize that. So there's a distinction.
So is what you're saying that even though 16 has this, after 2 years you don't necessarily have to show much, there is this sort of outer limit that if all you're really doing is after the fact challenging what was originally granted that you could have challenged then, the court is going to say, no, you can't use 16 to do that.
I would be hard-pressed to stand before you folks on a situation if I was challenging the validity or the application of the zoning ordinance to the facts of my case. So I would agree with that.
This is a minor point, but on page 30, the title heading here, and it's also the same in your table of contents, you say the trial court erred as a matter of law in annulling the appellant's decision and ordering the issuance of the special permit. Don't you mean the trial court did not err?
Did not err. Well, what I was doing was merely reciting the issue.
You're responding to their argument.
That's
Could I know you want to get somewhere, but the question that Mr. Costello has talked about, and it's obviously a real issue, what about the power of the judge? On this case, the evidence before her was what it was, and the witnesses who testified were your witnesses and not the town's. What about her power to actually order the granting of the special permit as opposed to remanding it?
Remand is a very useful tool when there are holes or the need for further substantive evidence. In this case, we've been down. The case had been remanded. The case had been tried in the Superior Court. There's no indication in the record before you that the trial court needed further substantive evidence.
No, but I guess what I'm thinking of is saying the trial court can say, what you did, town, was incorrect. Go do it again. You can't do what you just did. Go do it again. As opposed to, in Mr. Costello's words, substituting her judgment as to what should happen.
Right. In addressing the remedy first, in this case, no need for substantive evidence. Just go back and reauthor the decision without the conditions, I believe is what the judge did here. So there's no need to send it back. It would be...
I seem to remember trying a case, I think it's called Crittenden, very unusual, when the court ordered the affirmative release. Maybe my memory is going... But that, there was a long record of why it would be futile. Are you saying you meet that? you meet the futile test?
Yes, and I referenced that in my brief as well. Might be the Chera case, might be other cases that I reference in here. Although the general law is it's ordinarily it's improper for the court to order the issuance. But in this case, this is an extraordinary case. It's not unheard of, and it has been done. Justice Bartford.
Can I just?
Certainly.
Do you want to answer Justice Bartford? It's fine.
Well, no, there was an issue as to whether substituting judgment is something this court should look at. My brother did discuss the trial court substituting its judgment for that of the board. But that rule of law, or what my brother alludes to, is tempered by the Davis case, the Davis versus the Zoning Board of Appeals of Chatham, where the trial court is to defer to the local board. And if there is any rational basis for the denial that exists in support that's contained in the record, then in that particular instance, the trial court is not to substitute its judgment for that of the board, who is deemed to be familiar with local conditions. So in this case, Judge McAvoy went out of a way to say, hey folks, hey town, even applying that deferential standard, this court finds nothing to support the board's reasoning.
Well, but wasn't the administrative record introduced as an exhibit in this case?
It was.
And wasn't there something in the record which suggested that two witnesses or two people who lived on Pollard Ave, whatever the name of the street was, got up before the board and said, look, this is going to cause increase in traffic on our street?
Well,
I mean, isn't that in the record?
My memory is there may be something in the minutes. Now, I caution the court on what weight to give the minutes of a Board of Appeals hearing, and I believe this case law as to whether it should be afforded any weight, because you're in the de novo setting.
Yeah, but it's an exhibit in the case.
It is, but
it was entered into evidence, and so there is some evidence upon which the board based its decision. There is some evidence that there would be an increase in traffic to people on Pollard Street as a result of this new curb cut, and it would affect them.
But I would be careful on how you characterize that evidence. It's not some evidence of increase in traffic. It may be two neighbors that stood up and said, I have some concerns about traffic. Again, not articulating what those concerns are and what effect this restaurant will have on the neighborhood.
Well, the board's response to that is, well, first of all, this comes about not because of anything the board did, right? And not because of anything that you did. It's because somebody else wanted to fix the road, correct?
Correct.
Okay. So you've got a change of circumstances, got nothing to do with these parties. It's not as if you came in and said, you're not starting from a clean record. The board says, okay, we gave you permission on the old set of circumstances. That whoever it was, the state or the county, whoever, I guess the state changed the road pattern, and that impacts different people in different ways. It impacts you, and the board says, well, you go for diminution of value. If you say you're going to lose customers, it impacts neighbors who now, they're going to have more traffic, and they come in and say, look, if you cut a curb here, it's going to impact us, and the board weighs those and says if you could show monetary damages, go to the eminent domain assessment of damages. Why isn't that an adequate relief? I mean, why can't the board weigh those various things?
Well, I understand the issue of the eminent domain taking and the petition for damages came up during my brother's presentation. The Pro Tanto award was $116,000. That was for the 20-some-odd thousand square feet of land that was actually taken. The dispute and damages in this case were really the cost to cure damages. In other words, we had to redesign the interior of our site. We had to redesign the parking lot, redesign the landscaping, so that the difference between the Pro Tanto and what Wendy's really needed to be made whole had to do with having to re-engineer and redesign its site, because it had approximately 20,000 square feet taken and part of its parking lot. So,
but one of the considerations in the damages was loss of business.
Well, it is, but Wendy's, I guess it would be. Yeah,
is.
certainly.
And I mean, I don't know, there are people with more expertise, but when there are takings of eminent domain, that may be the appropriate forum. I mean, if you introduce evidence in that takings proceeding that this is going to substantially increase the danger to your clients, which may not be calculable, maybe that's the place where, there has to be an award. I mean, this puts the town, it seems to me, in a very difficult position. The town says, I didn't want to expand this load.
Well, I take it the town did want to expand the road.
Well, they
This was a
did.
town project funded by the state.
That's correct, and Mass Highway was involved. And remember, I cannot stress enough that Mass Highway or the Department of Public Works in the town of Billerica wanted us to do this. And as a matter of fact, they were pushing for this because they thought it was a safer alternative for the traffic pattern. They were pushing us. They were at the helm pushing this issue. Went to bat. As a matter of fact, in the appendix, you'll see that the town paid its own engineer approximately $4,000 to assist to a certain extent in re-engineering the interior of our site. So it's really a safety issue, not a diminution in value issue. We were again, it's a safety issue. There's no left-hand turn.
Have there been any accidents or any?
I know of one recently.
But it's not in the record.
Pardon me?
I say but the record doesn't show because this all
because we
took
tried this
place
some
before.
time
Sure,
ago.
yeah.
But wasn't the request for the variance presented to the board essentially on the basis of a loss of income, that this business is making, I think, 32% of the business that comparable Wendy's were making?
It
Wasn't that the testimony?
It wasn't presented to the board in that fashion. It was presented merely for safety purposes. Again, the town engineer and the DPW are pushing for this thing. It was presented to the board as a safety issue, which is well within the parameters of the zoning bylaws. Was not pushed as a diminution of value, although that evidence did come out at the time of trial. In other words, I believe the traffic engineer at the time of trial stated that the traffic to this particular site, I think is 32% lower, or whatever the percentage is lower than comparable sites. So we were not pushing the diminution in value. It was merely a safety issue that was nudged along by the Department of Public Works.
Do you acknowledge that economic basis is not a basis to grant a variance?
I would agree with that.
Okay.
I do not disagree. So very simply, clearly, the court has jurisdiction. It's a Section 16 analysis. It's a change of circumstance. I believe Your Honor asked about whether or not the entrance had changed before the remand. You'll see in the appendix that in the second decision, I believe it's on page 71 of the appendix, is the second Board of Appeals decision where it states reasons for votes. Item number 4, moving the access 10 feet north on Paula Street, it claims would not ease the traffic problem, although a conclusionary statement. There's some evidence there that
There was a change.
Yeah,
There was an effort to
there was a
move it.
change.
Okay.
Yes. They say 10 feet. My memory is there was a change in the location of it. There's acknowledgement in the record that the change was some 10 feet in any event. The more significant change, obviously, is what happened in our site and around our site that really compelled the need for the modification.
Thank you, Mr. Dangor.
Thank you.
We'll take a short break.